Hello, everyone, and welcome to Internet Law Review. For today's story, we have the United States Supreme Court case of Shoop versus Hill. This is a death penalty related case relating to a question of whether or not the inmate who is going to be subject to the death penalty was too mentally incapacitated to be subject to the death penalty without it triggering the United States Constitution's Eighth Amendment Cruel and Unusual Punishment Clause. This is a per curiam decision from the U.S. Supreme Court, which means there is no listed author, and is issued in the name of the court as a whole. So let's see what the United States Supreme Court had to say about this case. The United States Court of Appeals for the Sixth Circuit held that respondent Danny Hill, who was sentenced to death in Ohio, is entitled to habeas relief under 28 U.S.C. 2254 because the decisions of the Ohio courts concluding that he is not intellectually disabled were contrary to Supreme Court precedent that was clearly established at the time in question. In reaching this decision, the Court of Appeals relied repeatedly and extensively on our decision in Moore v. Texas, which was not handed down until long after state court decisions. So there are a couple things to note right away. First of all, this is relating to habeas corpus, and this is from the Sixth Circuit Court of Appeals, both of which are very important facts. Habeas corpus is what's sometimes called the grand writ. It literally means produce the body, but what it figuratively means is show the justification for why I can be put in jail or otherwise subject to punishment. So the writ of habeas corpus is a demand of justify why I'm being held. And it is considered the ancient and most important of the writs. In fact, it's specifically mentioned in the United States Constitution on how important it is. So this is an important writ. However, the Court of Appeals for the Sixth Circuit has been smacked down by the U.S. Supreme Court over the years on specifically this writ. The Court of Appeals for the Sixth Circuit has generally granted this writ in ways that the U.S. Supreme Court has found to be improper. And the U.S. Supreme Court has repeatedly admonished the Court of Appeals for the Sixth Circuit for their overbroad reading of habeas corpus law. Habeas corpus is meant for when no other remedy is appropriate. It's meant for extreme situations. It's not meant for the ordinary. And the United States Supreme Court has held, in case after case, that the Court of Appeals for the Sixth Circuit has applied this writ in situations where it is not appropriate. Here, right off the bat, the United States Supreme Court has said the Sixth Circuit has made a mistake, and they've said that in the first paragraph. They say the Court of Appeals relied on a decision which was not handed down until after state court decisions were reached. And that's very important because almost all decisions of the United States Supreme Court are without retroactive effect. That means they only apply to decisions going forward, not backwards. And so it is almost invariably an error for a court to say that a decision from the United States Supreme Court applies to decisions from other courts that happened before the United States Supreme Court rendered its decision. And the U.S. Supreme Court is telegraphing that's going to be exactly the situation here. The Court of Appeals for the Sixth Circuit, by relying on a case that did not exist at the time the state court made its decisions, has erred. And the United States Supreme Court has made that telegraphing move right away. So let's continue to see what they have to say. The Court of Appeals' reliance on Moore was plainly improper under 2254, and therefore we vacate that decision and remand so that Hill's claim regarding intellectual disability can be evaluated solely on holdings of this court that were clearly established at the relevant time. Again, pointing to exactly this standard. Decisions of the United States Supreme Court are almost always without retroactive effect. They're almost always forward-looking. And so the Court of Appeals made an error in relying on a decision that the state courts could not consider because the decision didn't exist at the time the state courts were rendering their finding. The United States Supreme Court is saying that if the Court of Appeals is to find an error, it must be an error at the time the decision was made, not one that's an error only looking backwards because of case law that did not yet exist. Having established the legal framework, let's look at the factual background of this case. In September 1985, 12-year-old Raymond Fife set out on his bicycle from a friend's home. When he did not arrive, his parents launched a search, and that evening, his father found Raymond, naked, beaten, and burned, in a wooden field. Although alive, he had sustained horrific injuries that we will not describe. He died 2 days later. In 1986, respondent Danny Hill was convicted for torturing, raping, and murdering Raymond and was sentenced to death. An intermediate appeals court affirmed his conviction and sentence, as did the Ohio Supreme Court, and the U.S. Supreme Court denied certiorari. After unsuccessful attempts to obtain post-conviction relief in state and federal court, Hill filed a new petition in Ohio courts contending that his death sentence is illegal under Atkins v. Virginia, which held that the Eighth Amendment prohibits the imposition of a death sentence on a defendant who is mentally retarded. In 2006, the Ohio trial court denied this claim, and in 2008, the Ohio Court of Appeals affirmed. In 2009, the Ohio Supreme Court denied review. In 2010, Hill filed a new federal habeas petition under 28 U.S.C. 2254, seeking review of the denial of his Atkins claim. The district court denied the petition, but the Sixth Circuit reversed and granted habeas relief under 2254, which applies when a state court adjudication resulted in a decision that was contrary to or involved in unreasonable application of clearly established federal law as determined by the United States Supreme Court. The Sixth Circuit found two alleged deficiencies in the Ohio court's decisions. First, the Ohio court overemphasized Hill's adaptive strengths, and second, the Ohio courts relied too heavily on the adaptive strengths that Hill exhibited in the controlled environment of his death row prison cell. In reaching these conclusions, the court relied repeatedly on our decision in Moore v. Texas. The court acknowledged that ordinarily, Supreme Court decisions that postdate a state court's determination cannot be clearly established law for the purposes of federal habeas statute, but the court agreed that Moore's holding regarding adaptive strength was merely an application of clearly established law by Atkins. So, the Court of Appeals for the Sixth Circuit acknowledged in its decision that decisions from the U.S. Supreme Court are not retroactive, but then cited it anyway, so they came up with the relevant legal standard and then ignored it. So the Supreme Court's irritation is obvious from that exact fact. The state filed a petition for a writ of certiorari contending the Sixth Circuit violated 2254 because a fundamental underpinning of its decision was Moore, a case decided by this court well after the Ohio court's decisions. Against this, Hill echoes the Court of Appeals argument that Moore merely spelled out what was clearly established by Atkins regarding the assessment of adaptive skills. Let's see if the U.S. Supreme Court agrees. The federal habeas statute, as amended by the Anti-Terrorism and Effective Death Penalty Act of 1996, imposed important limitations on the power of federal courts to overturn judgments of state courts in criminal cases. So right away we see there is a jurisdictional limit. State courts and federal courts are separate courts completely, and normally federal courts and state courts should not interfere with each other's decisions. Federal courts should only get involved with state courts for clear constitutional violations because of the separate sovereign doctrine of federalism, a doctrine that is somewhat controversial for a number of reasons, but this is the factual underpinning of our legal system. And so Congress passed the Anti-Terrorism and Effective Death Penalty Act, which constrained federal court jurisdiction as it relates to death penalty cases and other cases relating to habeas corpus for exactly this reason. Judgments of state courts are assumed to be valid, and federal courts should not generally interfere. The Supreme Court continues. The statute respects the authority and ability of state courts and their dedication to the protection of constitutional rights. Thus, under the statutory provision at issue here, 28 U.S.C. 2254, habeas relief may be granted only if the state court's adjudication resulted in a decision that was contrary to or involved in unreasonable application of Supreme Court precedent that was clearly established at the time of adjudication. This means the state court ruling must be so lacking in justification that there was an error well understood and comprehended in existing law beyond any possibility for fair-minded disagreement. So you can see here, right again, the Supreme Court's laying out the standard. To get habeas corpus relief, it has to be in violation of clearly established law. And clearly established means the court made an error that no person could reasonably disagree with. That is the relevant legal standard. The Supreme Court continues. We therefore consider what was clearly established regarding the execution of an intellectually disabled person in 2008, that's the critical date, when the Ohio Court of Appeals rejected the Atkins claim. Of course, Atkins itself was on the book, but Atkins gave no comprehension definition of mental retardation for Eighth Amendment purposes. The opinion of the court noted that definitions of mental retardation adopted by the American Association on Mental Retardation and the American Psychiatric Association required both sub-average intellectual functioning and significant limitation in adaptive skills such as communication, self-care, and self-direction that became manifest before the age of 18, again showing some critical dates. The court also noted that state statutory definition of mental retardation at the time were not identical, but generally conformed to these clinical definitions. The court then left to the states the task of developing appropriate ways to enforce the constitutional restriction that the court adopted. More than a decade later, the Supreme Court expounded on the definition of intellectual disability in two cases. In Hall v. Florida, the Supreme Court considered the rule restricting Atkins to defendants with an IQ test of score of 70 or less. We held that this rule violated the Eighth Amendment because it treated an IQ score as higher than 70 as conclusively disqualifying and thus prevented consideration of other evidence of intellectual disability, such as evidence on deficits in adaptive function over the defendant's lifetime. So the Supreme Court said that this test is not as simple as a simple IQ test, because someone higher than that metric might qualify because of other indicators. Fair enough. 3 years later and more, the Supreme Court applied Hall and faulted the Texas Court of Criminal Appeals for concluding that the petitioner's IQ score, some of which were at or below 70%, established that he was not intellectually disabled. We also held that the CCA improperly evaluated the petitioner's adaptive functioning. It erred, we concluded, in overemphasizing the perceived adaptive strength despite the medical community's focus on adaptive deficits. And we found that the CCA also went astray in stressing the petitioner's improved behavior in prison, even though the medical community cautioned against relying on adaptive strengths developed in a control setting, as prison surely is. So again, the Supreme Court is saying that this is not as simple as a bright line rule of an IQ of 70. You have to consider all the relevant factors, but you have to consider the factors in the broader community at general, not just in the prison environment, because the prison environment, because of its regimented routine environment, is not the relevant environment. We're trying to determine the incapacity of the person in society as a whole, and the Supreme Court noted that there was a fault there for over-relying on the behavior in the prison environment. So, fair enough. Returning to the case at hand, the Supreme Court says, in this case, no reader of the decision of the Court of Appeals can escape the conclusion that it is heavily based on Moore, which came years after the decision of the Ohio courts. Indeed, the Court of Appeals, in finding an unreasonable application of clearly established law, drew almost word for word from two statements in Moore quoted above. This is not a positive sign. If a Court of Appeals is citing something that happened after the state court made its decision, this is a legal error, and the Supreme Court is saying that exactly here. Although the Court of Appeals asserted that its holding in Moore was merely an application of what was clearly established in Atkins, the court did not explain how the rule it applied can be teased out of the Atkins court's brief comment about the meaning of what it termed mental retardation. While Atkins noted that the standard definition of mental retardation included as a necessary element significant limitations in the adaptive skills that became manifest before age 18, Atkins did not definitively resolve how the element was to be evaluated, but instead left its application in the first instance to the states. Moreover, the posture in Moore reached this court, and the Moore majority, primarily reliance on medical literature, the post-date of the Ohio court's decision, provide additional reasons to question the Court of Appeals analysis. The centrality of Moore in the Court of Appeals analysis is reflected in the way in which the intellectual disability issue was litigated below. The Atkins portion of Hill's habeas petition did not focus on 2254, the provision on which the decision is based. Instead, it began and ended with appeals to different provisions of the habeas statute, which support relief based on a state court's unreasonable determination of facts. In particular, Hill opened with a claim that the Ohio court's finding on adaptive functioning were on a reasonable determination in facts of light of evidence. Hill also closed with the claim that the state court's assessment that he was not mentally retarded was based on an unreasonable determination of the facts. Indeed, Hill replied to the state's answer to his petition explicitly concurring that it's proper to review the claims under 2254. So Hill is making a specific legal argument with a specific claim, and the Court of Appeals is to consider the claim that he's bringing. So, did that happen? According to the U.S. Supreme Court, the District Court analyzed Hill's-Atkins claim solely under 2254, noting that as Hill concedes in his traverse is a phrase that means a response. So he's responding to the government. So that's what it means to say a traverse. As Hill concedes in his traverse, his Atkins claim is more appropriately addressed as it relates to the Ohio Appeal Court's factual analysis. Hill presented this same argument in his open brief in the Sixth Circuit. There he argued that the state court's finding on adaptive functioning was an unreasonable determination of the facts. It appears that it was not until the Court of Appeals asked for supplemental briefing on Moore that Hill introduced the 2254 argument the Court of Appeals adopted. Supplemental arguments cannot broaden the legal definition or the legal arguments that are made in the original petition. They're meant to flush things out or explain aspects better, but they are not used to raise additional arguments. So when you make your initial petition, you're bound by that argument. Supplemental briefing is meant to expound on something to greater detail, or to respond to something the government said, or to highlight something in greater detail. That's not meant to bring in new arguments. So that is improper to do that in a supplemental briefing. Although, as noted, the Court of Appeals ultimately disclaimed reliance on Moore, explicitly asked for a supplemental briefing on how Moore should be applied. Yeah, you can't have it both ways, Court of Appeals. Which one is it? Are you disclaiming it or relying on it? So this is completely muddled. Because the reasoning of the Court of Appeals leans so heavily on Moore, its decision must be vacated. On remand, the court should determine whether its conclusions can be sustained based strictly on legal rules that were clearly established in the decisions of this court at the relevant time. So that is the case of Shoop versus Hill. Hill is a convicted murderer, having been convicted of the aggravated murder of a 12-year-old child who was burned to death and left to suffer in a field. I think we can all agree that this qualifies as a horrendous crime, and first-degree murder is reserved for these kind of aggravated murders. So that would seem to be appropriate for that legal definition. It's not just a murder, it's a murder with the torture element. So it seems that Hill was convicted of this, and no one seems to be disputing that Hill indeed committed the offense in question. Rather, the dispute is over whether or not he is insufficiently mentally competent to be executed, because the law says that you cannot execute a person who is too mentally deficient to understand what is happening to them. But the Sixth Circuit Court of Appeals, as it so frequently does, messed up the habeas petition. I'm telling you, the Sixth Circuit does this all the time in habeas petitions. I don't know why, but the Sixth Circuit gets reversed all the time in habeas. You would think that they would learn their lesson, but at some point, that hasn't happened yet. So the U.S. Supreme Court has again reversed a decision of the Sixth Circuit saying, look, you guys completely screwed up the law. Once again, go back and do it right, indicating the trial court did it right, and seems to be indicating that the Sixth Circuit should affirm the trial court, because I'm having a hard time imagining how the Sixth Circuit, applying the relevant legal standards at the time the state courts made its decision, is going to be able to overturn the decision. And it doesn't seem like that's possible here. So I would expect the Sixth Circuit of Court of Appeals to deny the habeas petition, having been once again slapped down by the by the U.S. Supreme Court, and the death sentence to be once again reimposed, because that seems to be the direction here. So that is the case of Shoop versus Hill. I hope this was helpful. Until later, my friends, cheers and goodbye.